News that impacts you and your community. 13 on Your Side Evening Plus starts now.
Good evening, everyone, and welcome into Evening Plus. I am once again joined by Lauren Baker as we continue to break down the trial of Christopher Schurr that continued and wrapped up its second day today. Lauren, we saw significantly less witnesses called to the stand, only 3 today, but much longer testimony, really in depth. Just starting with you, I mean, what stood out today as you were there minute by minute, just listening to everything from here in the studio?
I think the biggest thing that we saw is this truly was the kind of setting the stone for setting the tone rather for what we're going to see for the rest of the trial, which is both the prosecution and the defense using experts to really get their case across. We saw one of the main experts today, which was an professor and former law enforcement officer and a lawyer, talk about use of force. He was the use of force expert for the prosecution, and he was heavily interviewed and many times was kind of the source of arguments between the prosecution and the defense, because the defense felt like that his opinion was not relevant because he has reviewed this case. The prosecution obviously thinking otherwise. Yeah,
there was quite a bit of back and forth between the prosecution and defense, as you mentioned, sort of some hot moments of, okay, can this be an objection or can it not? And the judge obviously making the call there. And yeah, we heard from a Taser expert and then 2 use of force experts today. And, one of those testimonies was very lengthy, was the longest we've seen so far. We also have Callie Lichter, Josh Albertus, and Riley Mack, who have been inside the courthouse throughout this for day 2. Guys, initial reactions from you all just on how day 2 panned out.
Yeah, thanks for having us tonight, you guys. All 3 of us have been inside the courthouse today, kind of keeping track of what's going on. Very different from yesterday when we had 8 witnesses on the stand. It was pretty quick. There was not that much argument between attorneys. It was very minimal. Today, only 3 of those witnesses and experts, and very lengthy cross-examination. We started the day at 9:01 with Brian Childs, who is determined to be an expert on the Taser aspect of this case. He works at Axon, which is a Taser company. He first testified that there are no long-term impacts from the Taser, and that there's, the Taser is best effective within 4 feet to 25 feet. First saying that, the only way you could get a serious injury from this Taser is through the eye or possibly death if you fell from a great distance, but it would be very unlikely. But when the defense kind of cross-examined him, the narrative kind of changed around the Taser, where it was, it could be lethal. It is possible to be dangerous in the hands of a person who doesn't know how to use it. And that testimony went on for about 2 hours. The biggest point is that the Taser has the power to incapacitate, and it could have been used to incapacitate Schurr during that struggle, and it could have ended in Schurr's death. And the defense is kind of trying to frame it that way, where the Taser could have been used by Lyoya to maybe possibly get his gun and use it on Schurr. And so that changed just over that 2-hour cross-examination. I want to know your guys' thoughts on that from the legal aspect.
I mean, we knew from the get-go that the Taser was going to be the crux of this argument. I mean, you have the prosecution on one side who is trying to argue this second-degree murder charge, this felony murder charge, that, this was an intentional shooting and that it was unjustified. And we knew that the defense was going to come out and trying to, say Schurr was scared for his life, and that's why the Taser is at the crux, because you have both sides trying to argue, what was the Taser going to be used for, with the defense saying that Lyoya was planning to grab the Taser, and that if he got the Taser into his hands, he could have, disarmed Schurr by getting his gun for I believe 5 seconds that a Taser could stun someone with a neuromuscular incapacitation. And so you had the first hour that focused really on that, on the prosecution saying, this Taser is not deadly, it could not create great bodily harm, so that they could try to prove that the use of, death, great bodily harm, was not a good response. And then on the flip side, you had it then proved that there are circumstances where the Taser could be used in a way that could create that great bodily harm or death.
And whether or not this was justified and what will or will not be proved really played into something else that we saw even outside the courtroom today. This was something that we saw yesterday start off kind of when we had a lot of those demonstrations outside the court yesterday. A lot of them pertain to a new bill that was being introduced by a state lawmaker from the east side. And today that was actually put into the legislature's online database. So we kind of got the exact language of what we were expecting, what would be proposed. And it kind of relates to what people feel are similar cases. There's been no clearing here, no conviction on the other side either. But what we were seeing here from this bill, from this legislation, this proposal was for people who have been acquitted of criminal charges relating to certain instances of deadly or non-deadly force that falls under the state's Self-Defense Act. If they were acquitted of those, that contributes to having civil immunity from civil cases aside from the criminal side. And that's just, important to mention because, it had to be mentioned that, the Leoya family had filed a civil suit against Schurr on top of the criminal trial. So they kind of used that yesterday. This lawmaker was here yesterday using the courthouse as kind of a backdrop on this first day of this case. And that's something that we were seeing and then we were tracking today also as we got the exact language of that proposal and, what was being proposed as they used this courthouse, seemingly this case as, the face of that announcement.
Absolutely. I'd love to show the viewers, those sound bites from Childs in court today, speaking on the relevancy, like you said, of, these issues with tasers and things like that coming up right now. I'd love to show the viewers that.
And you have this warning here. You just said it's not designed to kill people, but then you have this warning here. Can you explain that?
So the warning, the first point, can incapacitate. That's what it's designed for. Can cause death or serious injury. Serious injury, you can get a probe in the eye. You can, using force, you can cause injury. As far as death, most of the deaths that have happened from falls. When a person walks up and they're incapacitated, they typically fall down, and if they're at elevated height, they fall straight to the ground. Or head injuries can happen as well. So it can, almost anything can cause death. But taser energy weapon, it's not designed to, but if used improperly, it can.
Sort of watching just to clarify some things. When we're talking about that, when this expert was being questioned and that it was almost like a back and forth between the prosecution and defense, it's not that he was changing its question. What happened and what you saw was that the defense and prosecution were asking very you know what I'm trying to say? Specific questions. So like you heard him saying that, there is possible serious injuries. What he's meaning is that, yes, if I shoot you with a taser in, let's say, your leg, you're not going to receive a large injury from that.
Right.
But let's say that you do get injured, you do get tased and you're at a higher elevation and you fall, that could result in a very serious injury. So it's not that he was going back and forth on what he was saying. What was actually happening and what we now can see is going to happen for the rest of this case is that the prosecution and defense are going to be asking very specific questions and asking for specific details in their questions to actually prove their case.
Right. They're asking them in a way that's going to, push toward the narrative that they're trying to tell in order, obviously, to side with the person that they're representing. And you see that often, and sometimes it comes up too, which I think is interesting as you're watching this lengthy testimony, is that these experts can only speak so much to what is their, kind of their wealth of knowledge. And we did hear many times today where one of the three witnesses would say, oh, that's not my area of expertise, or I can't exactly speak to that, or no, that's not exactly what I'm saying, because, obviously in certain scenarios with some of these experts, they can't speak to everything. They can't, explain everything that maybe the defense or the prosecution is trying to get at. Their wealth of knowledge is limited to just their field, which I think is interesting. And I also wanted to point out, we're saying expert, and that's something that's brought up and was heavily questioned today as well. These people don't just roll up to the stand and they're an expert in whatever field. There's questioning that happens on both sides to sort of get them and get the judge to agree that that's okay. Can you walk us through that a little bit more too on how that works?
Yeah, so before the trial even happens, you have to have your list of experts and witnesses that have to be either agreed upon or not. And you actually saw that happen today. You saw the defense once again trying to put an emotion or objection to get one of the witnesses taken off the stand because they felt that his view was not relevant to the case because he was, and another part of that too was that he is a former police officer, and so they used the word jeopardy a lot. They felt that he was going to kind of bring this case into jeopardy because he was a former police officer and he would have certain ideals.
Right.
Ultimately, the judge did not agree with that, obviously allowing him to stand, and he was on the stand for well over 4 hours today. But that's just kind of things that you're going to be seeing, is that you're going to be seeing experts that have, in their opinion, the opportunity to be able to speak about things to prove their case.
Absolutely. And we've got another big chunk of testimony today from Brian Childs, who you heard from just a moment ago. He's that Taser expert. He works for Axon, a Taser company. Let's roll that now so folks can hear a bit of that.
Now, from watching that video, you can't tell whether or not the officer noted there was a second cartridge deployment, can you?
We have a jack that goes kind of beyond his expertise here, Your Honor.
He's just testifying to his observations of the video, but
I think he would have to speculate, so I'll sustain that objection.
watching the video after the second cartridge deployment, does the officer continue to fight to attempt to get the weapon? Is that your observation?
Yes, they continue fighting over the weapon.
And does the officer seem to continue to treat the weapon seriously?
It appears so, yes.
And does he continue to tell the other person to let go of and drop the taser?
Yes, I believe that's the words that he was using.
But now we know, based on the benefit of a video and data, that there was a second cartridge deployment, correct?
Correct.
But even after both cartridges were deployed, 5 seconds goes by. Based on the proximity of Officer Schurr in that video to the probes and wires, and what you explained as far as this ability to re-energize the probes or wires, the drive stun, could Officer Schurr still have been at risk of suffering the effects of NMI?
Yes, he could.
And could that have been by contact with probes or wires?
Yeah, contact with probes, wires, or drive stun. All the above could have caused NMI.
Do you think that even with both cartridges deployed, 5 seconds passes, that the taser still deserved its classification as a serious weapon?
Yes.
And what you just heard is he's actually kind of going into the next part after this. He's talking about after the taser has been deployed twice. There's people who don't know how to use a taser. What they're explaining is that even if it's been deployed twice, you can still actively use it. It's called a dry stun, and it's actually, if you take the gun and you now I'm not an expert, but there's a button on the taser that if you physically put the taser on a person and you push that button and the safety guard is off, you could still hurt them. It won't be to the degree of like severely hurting them, but it's still a shock.
And just to kind of contextualize too what you're hearing there, it's, you know, obviously it's question after question after question, but what we're, you know, the case that the defense appears to be making is that, okay, you know, if it's so complex, but you know, it's all surrounding the taser, because had the taser been, you know, had Officer Schurr been shocked by the taser, you know, could that have played a role in then why the gun was used? You know, that's why all of this questioning is happening surrounding the taser use, and you know, how dangerous can the taser be? What can the taser enable to happen? You know, and that's why there were so many specific questions about what exactly can happen. And you know, once the probes are dislodged, you know, then we go into what you were just mentioning. So you know, it's a lot of questioning, a very thorough look at everything that can happen there and how that may have or could have played a role in what happened down the line in that scenario.
And more importantly, really showing that just because the taser had been deployed twice, that doesn't mean that it cannot, that it's done, that he can't do anything more. That's the whole, because you hear, when you listen to the audio of the videos, you can hear it click twice. You can hear a pop that is showing that the taser has gone off. So their argument is saying, hey, look, he's still reaching for the taser after it had been deployed twice. is that good or bad? And the defense is saying it's still bad because this is what could happen.
This is what could have happened. Yeah, it's a lot of hypothetical questions that play into what actually happened. We'll bring our reporters in the field back in now to move on to that second witness, guys. And this was Seth Stoughton, a professor of law and criminal justice at the University of South Carolina. But he was also more so, that's his background, brought in as this use of force expert, one of two whom we saw testify today. And guys, if you will, walk us through a little bit of what you saw happen in this testimony and what sort of the prosecution and then in cross-examination was trying to be, argued here.
So we knew that Stoughton was going to be a controversial witness for the defense, like from the get-go. There was motions to try to dismiss him as a witness even before this trial even started. And the first hour of his questioning was just from the defense to try to get him not on that witness stand. And we kind of saw why the prosecution was really pushing to have him on that witness stand today in the trial. A lot of the prosecution's argument really hinges on this concept of it was not a justifiable use of force. And that's exactly what Stoughton was saying to the jury, to the people in the courtroom, to the attorneys today. He believes that it was unreasonable and unjustifiable for Schurr to pull that trigger on that gun. And he was really, really standing his ground on it. When he was being cross-examined and even examined for hours, like Lauren pointed out, it was around 4 hours, if not more than 4 hours, that he was on that witness stand today. And, as many times as he was cross-examined by Matt Borgula, who is Schurr's attorney, he was standing firm in his statement that this was unreasonable. And, sometimes the defense attorneys will try to question a witness to try to get them not exactly to, slip up. You need to be 100% truth and faithful when you're on that witness stand. But, to say something that can go against a prosecution, we need to remember that this is a prosecution witness. We've only heard prosecution witnesses up until this point. And so as many times as he was trying to get him to say, do you not agree? Is there something that may be questionable, in the years that you've known about this case? Stoughton was standing firm in his resolve that he was not changing his opinion, and after he's reviewed, all the material that he's been given on this case, he still believes what he believes.
Yeah, I also think, the main piece of his testimony was he spoke on the three decisions that Schurr made that April morning. One being pulling Lyoya over, which he says was, justified because Lyoya, had mismatched plates on his car that did not match up. So he pulled him over. He said that was lawful. He made the decision to, chase after him when Lyoya started to run, which was a decision where he said, I think that's the end of the justifiable behavior to him. And he said, during that point that he had his back facing to Lyoya's passenger in the car, which was not something that a police officer should do. They should be thinking about their own safety, minimizing their own risk, as well as, catching the person that is trying to escape. He said that in a different situation, a police officer should let the person go sometimes when they're running away to maximize their own safety. And possibly that passenger in the car could have told him who the person was that ran and helped him arrest him later. But it didn't happen that way. And then it comes to that, what, Borgula, who's the defense, said the ultimate question that, is that final decision that Schurr made, which was to use the gun on Lyoya, which he said it was not justifiable in the end. And I think it really came down to those three major action points that he spoke on during his testimony.
And guys, we have a clip from testimony today talking about exactly what you guys were just mentioning, what Lauren and I were talking about. Let's play that now from Stoughton. Appears we're having a bit of a technical difficulty with that, but that piece of testimony today, I can kind of review it for you guys, is exactly what what Riley was just talking about, and that being, pairing together the use of deadly force, and was that reasonable? And I don't want to repeat what Riley was basically just saying, but I did want to add that what was kind of being used as kind of the comparison point here was basically, widely known police practices. That's what Stoughton was talking to, was not necessarily, Grand Rapids Police, handbook specifically or other cities, but, what's widely done by police, across the United States, and would this adhere with, what most police officers would be doing is kind of where the point of comparison was coming from. And as Riley was saying, each step of what we saw happen in the video that so many people have said is just, okay, was this justified? Yes or no? Was this justified? Yes or no? And then when did things sort of take a turn, as Riley got to?
And during his testimony, we actually saw more tense moments. Like we've mentioned like Callie mentioned, there was a motion to try to get him to not be on the stand. Even after he was on the stand, after first cross-examining him, jurors actually left the room, and they made another point, the defense made another point to say that they didn't believe that he had the qualifications to be able to talk about taser use. And that was a back and forth, and ultimately the judge did side with the prosecution, saying no, he can speak about those things. Well, rather, she was saying that the prosecution had not asked those questions yet, so that way he could speak about those things. And even when he was asked about the taser, he was very specific in what he was saying. At one point in time, they had asked about, if someone had been hit by a taser and they were incapacitated, would that make the situation worse? And he explained that if that could happen, let's say a person does sting someone with a taser, that person becomes incapacitated, and that person is able to not only keep that person incapacitated, but also grab the gun and then do, some unfortunate things that, yes, that could happen, but he said in his testimony in the history of police that has not happened.
And the likelihood of being able to do all of those things in the amount of time that this specific situation here happened would make that even more unlikely. We have that clip now ready about that, reasonability and deadly force from Stoughton's testimony. Let's take a listen.
Therefore, that Officer Schurr, for Officer Schurr to use deadly force, if he in fact held a reasonable belief that he was in risk of being incapacitated or tased?
Okay, so what I think I understand your question. What you're asking is the threat of being tased, does that create an imminent threat of death or great bodily harm, such that the use of deadly force is then justified? For that to be plausible, the threat would have to be the subject has the taser, which is in a condition to actually incapacitate. The subject, there is at least some reason to believe the subject knows how to use the taser, like disarming the safety and using it. That the taser, which is a weapon with a less than 50% effective rate, will be effective in incapacitating the officer. That the officer will remain incapacitated long enough for the subject to access a retention holster, and that the subject will know how to remove a firearm from a police retention holster, and that the subject will do all of that in the period of incapacitation, which is either 5 seconds with a taser pull or an unlimited amount of time, I suppose, until the battery goes dead if you're holding the trigger of the taser down, which means you're doing all of this one-handed. While I think it is at least theoretically plausible that that could happen, it seems unlikely, which might be why, going back to the history of the introduction of taser use, that has never happened in American policing or internationally that I'm aware of. So I think it is theoretically possible.
And that's how you know that Lauren really knows her stuff, because that's pretty much exactly what she just told us. I wanted you guys to, hear all those checks that would have had to happen in order for this really to, be plausible, and that, helps the, prosecution's side, which is exactly why they called this witness to the stand, that, okay, is it possible? Sure, but, is it really feasible. Obviously it doesn't sound so much as so. And guys, I wanted to, I feel like we've sort of talked about these topics quite a bit so far this half hour, but being in the media room where you guys are you seeing, any reaction from the jury, any emotion being displayed on their faces, anything like that you've noticed, just in the last 2 days?
So, actually, we are not allowed to see the jury. That's one of the reasons why we can't be in the courtroom, why no cell phones, electronics are allowed in the courtroom. Riley and I were able to see the jury members who were selected, those 14, during jury selection, because that was an open courtroom. It's an open courtroom now. It's just we need, our laptops, our phones to be able to record, our cameras. We can't have those in the courtroom because it's to protect the identity of those jurors. Even when jurors have a question, it goes down so we don't see them. The camera is perfectly positioned so that we don't see the jury members. But we have been able to see some of that gallery. There are 44 seats reserved for the public, and then there is one row in front, or I guess in back, of the defense, and one row in the back of the prosecution, saved for both people invited by the Schurr side and the Loyola side, the prosecution side, respectfully. But just from seeing this witness testimony, especially yesterday when the friends and the neighbors testified, you had that one neighbor, Wayne Butler, who was talking about how this was a very emotional case, how he could only see the video as many times as a human should see the video. And if that's the response that we're seeing from the people who were there, I can't imagine the response from both Loyola's family, who has been sitting in court this whole entire time, and also Schurr's family, who has been standing behind him throughout this whole entire case. So even though we can't see the emotion because the camera's trained to a very specific part of the courtroom, I'm sure this is a very, very emotional time for everyone involved, especially sometimes when we have to go frame by frame to the phone video, to the dash cam video. Again, probably not a very comfortable situation for anyone in that room.
And I want to note too, Callie and I were there for, like she said, for jury selection, and we were able to find out, how many of those jury members saw the video before this case. It was, for a time, it was a very popular video. It was everywhere. It seemed like in Grand Rapids, and it was all over the news, and most of the jury members did know about the case. It was very rare to hear from a potential juror who had no idea what this case was. So the members of the jury, half of the jurors are seeing the video for the first time in court, half of them. 21%, have seen the video before this, but said they did not know much about the case. And then a small percentage of the jury, we don't know if they've seen the video, but again, they said they don't know that many details about the case. I think there were only 1 or 2 people that were selected for the jury that knew a lot about this case. So a lot of people, they're learning these details as they're happening in the courtroom.
Definitely. Guys, I think unless any final comments, I think Josh has something to say, and then we'll wrap it up from you guys, as we just have under about less than 2 minutes until the end of show.
Yeah, that's just something that I wanted to touch on, the kind of the potential emotion that Callie was thinking, that was touching on as well. I mean, I was speaking to, I spoke to another person who was outside. We saw much of fewer people outside the courthouse today than we saw yesterday, but there were still some supporters of the Loyola family, and one that I talked to, they began to cry. They began to choke up when they were talking about kind of the same thing that Callie was mentioning, when they believe, the family has had to sit and watch and relive that moment through the video multiple times at this point. That they've been watching it over and over, and it's something that certainly has been seemingly resonating with just not inside that courtroom. If it has been resonating inside that courtroom, again, we can't see the jury on the video, but also outside in the community as well. It is a message that has certainly seemed to resonate with people as we've continued to see people, again, fewer, but there has still been a presence outside this courthouse both days when it comes to either side of this case.
Definitely. I appreciate all of your insight from you guys in the field. Going to get you on your way and get you home. Thank you so much for joining us again for Evening Plus. And we know that you'll all be, of course, back in the courthouse tomorrow continuing to cover everything. So thank you again, guys. And again, tomorrow, day 3. Were you aware, was this the wrap of the prosecution's witnesses, or are we not sure on that?
So I actually had to get ready for the evening show, but I believe that they had one more person that they were still talking to. I'm not sure if that wrapped up, but if that did, then we will see their wrap up tomorrow.
That's what we would see. Okay. All right. Well, that is going to do it for us tonight, guys. Again, Lauren will anchor our streaming coverage bright and early tomorrow morning. We have our live blog on our website, and then we're constantly putting important clips up on YouTube and online. So we've really got you covered no matter which way you're able to tune into this big trial here in our city. Lauren, thanks so much for being here.
You.
And we'll see you right back here tomorrow night.